The death penalty is a great example of a case study involving the supremacy clause. This map shows you the number of people executed. The map's a little outdated, but roughly the number of people executed in every state since 1976. And that 1976 is a really important number that we'll come back to in a second. So the bottom line is the national government allows the states to choose if they want to implement the death penalty or not. Many states have begun to outlaw the death penalty on their own, but if states want to implement the death penalty, the national government allows them to do that. However, the reason why this is a great example of the supremacy clause is, though the states are given the choice of whether or not they want to be able to implement the death penalty in their state as part of punishment or not, from time to time, the national government has put additional regulations onto the states that they force them to follow. So, for example, in 1972, in the case of Furman versus Georgia, the Supreme Court basically told the states, all right, we're taking charge. We're taking this out of your hands, and we're not going to allow you to execute anybody for the time being. The reason why they did this was they found that from state to state, sort of the criteria to qualify for the death penalty varied like too greatly. They also found that a disproportionate number of minorities were being sentenced to death for crimes that when white people or non-minorities committed those crimes, they were not being sentenced to death. So because of the disparity in the way the death penalty was being implemented, the Supreme Court suspended the state's ability to implement the death penalty until there could be greater consistency in how the states used it. The states made enough improvements or changes or coordinated enough over a 4-year time period that in the case of Gregg versus Georgia in 1976, after a 4-year freeze, allowed the states to begin to implement the death penalty again. And then from time to time, the national government will jump in throughout the course of history and tell them that there's additional rules you have to follow. For example, in Coker v. Georgia, it was established by the Supreme Court that rape was not a death penalty worthy offense. So here's the national government jumping back in and telling the states, okay, you can use the death penalty again, but you can't now use it for this particular crime. Or jumping back in 2002, in the case of Atkins versus Virginia, when the Supreme Court declared to the states that it was unlawful to execute someone deemed to be mentally ill. So here's another restriction they're forcing the states to follow. Or in Roper v. Simmons in 2005, where the Supreme Court told the states that no longer could you execute anybody under the age of 18, no matter what crime they committed, that the juvenile death penalty would no longer be allowed. Or in the case of 2008, where the Supreme Court in Bays versus Reese ruled that lethal injection is not considered to be a cruel and unusual punishment. So it's an example of the supremacy clause and federalism because states are given some choice, but from time to time, the national government jumps in and establishes regulations that guide what the states can do and forces the states to follow basically the guidelines that are put into place by the national government.